with the second installment of our con. दरवाजा please बंद करो. We're back again with the second installment of the conversations we're having at the Breathe Pakistan conference. And we have with us senior puisne judge of the Supreme Court of Pakistan, Justice Mansoor Shah, who has delivered his keynote on climate justice. Welcome to the conference, welcome to our conversations, and you've delivered your remarks on climate justice and having the right to life linked to the action of climate justice and the provision of climate justice. So this is what I want to, I think, start our conversation about. When we look at Pakistan's constitution, we have guaranteed fundamental rights. What is the Supreme Court's view or overall legal understanding of how the right to life is linked to environmental and climate justice?
So it all started in the 90s, early 90s, when we were just dealing with environmental issues. Climate change had yet not set in. And so at that time, we used Article 9 of the Constitution, and all the courts in the world progressively interpret their fundamental rights. So we progressively interpreted right to life to mean right to an unpolluted life, right to life to a clean life. So that's how we also kind of brought in the international environmental principles like public trust doctrine, the precautionary principle, the intergenerational equity, and a number of other principles, and amalgamated them and weaved them into our fundamental rights, and particularly at that time, right to life. And subsequently, while interpreting our constitution, we brought in right to dignity, which kind of is far more strong a right and has more energy compared to right to life, because dignity is non-negotiable and it's so intrinsic and so basic to human beings. So right to life, right to dignity are now basic fundamental rights which protect and which talk about providing for a clean and unpolluted life.
And given the development of this particular subject, it's also incremental because there was initially the interpretation of the right to life and its link with environmental rights. And now we see that the Supreme Court is moving beyond and also linking access to climate finance, access to adaptive capacity, all of that to the right of life as well. So given the complexities, how does the court really view these new subjects that are becoming attached to the domain and think that how can we further take this as a climate justice subject?
Right. So when climate change comes into the picture, we realize that, as I said earlier, there's no polluter in the country, but various sectors get affected. Irrigation is affected due to water scarcity, due to global warming. Agriculture gets affected due to droughts or floods, and urban planning is affected. So initially, matters that came before us, nobody raised the question of climate change in it. But we realized that, for example, a cement plant in a water scarce area wanted expansion. And we looked at it and we could have said, no, sorry, you can't expand because there is no water in the area. But then we thought that there's a bigger picture at work. And that was climate change. This global warming, this is going to dry up this area. So we brought in the dimension of climate change into that cement case and said, no, you can't expand this, not only for any other reason, but also because climate change is going to affect the rights of the people there. And then we connected all the effects that climate change brings to life would be to the right to life, right to dignity of people. And that's how climate change sort of comes in. And we realized that we have to quickly adapt to the needs. And that's why the entire canvas of the paradigm shift came in our understanding, because earlier it was very simple to just shut down a factory, to penalize a polluter. But things were very different now. We had to come up with infrastructural changes, provide climate resilience, sustainability into urban planning, into agriculture, irrigation, forestry, you name it, you see. So it was a very diverse and a very broad-based aspect. And we kept going. We kept going. We said, we kept directing the government to come up with adaptation policies, and the government had policies. It was not as we were creating things. There was a climate change policy which had adaptation measures already built in. So we were just pushing the government to do what you were telling us to do. So please come up with your adaptive measures to deal with things. And that's how we brought adaptation and adaptive jurisprudence out of, for the people and to protect people. But then we soon realized, and this is just a recent thing that's happened, we've realized that these directions where we're telling the government to go adapt, and they say, yes, sir, we'll do it, we realize that they can't because they don't have the money, because adaptation is a very heavy financial cost is involved. So where will they get the money? And that's when we started looking at climate finance, and we realized that climate finance becomes so critical now in dealing with climate justice. There can't be any climate justice without climate finance. So we thought that then the new interpretation and extension of right to life and
Islamic finance as well. I think this
That's
is an
right.
example of the faith-based climate action as well.
That's right.
So what drove that sort of understanding?
The thought behind that was that we've been coming out with judgments for the last several years. We think that people are not really connecting with this issue, and we thought, what is lacking? And it so happened that we said, let's look at our own religion and see what does that provide for environment. And we realized that it's actually seriously talks about environmental issues, and it's replete with references to the environment. So we thought the best way to reach out to people, more effective jurisprudence could be where people could understand and relate to what the court is saying, and what better medium than the religion itself that they practice, that we practice. So we just came up with references, and we came up with Islamic environmentalism, which has been there. I mean, there have been thinkers, lead thinkers on these issues who've been talking about it, and we've mentioned those in the judgment. And I think that has created that impact, that our religion tells us, part of our faith to be environmentally sustainable, to have sustainable development. And that's why I keep referring to Islamic finance, because the more I read about it, I think it's such a natural fit to our issues, including climate finance issues.
I think my last question is going to be slightly different. We know that the higher court or Supreme Court's understanding has evolved to grasp the realities, but it has to flow down to the lower court level as well, or at least to the level where people's problem, which to an extent in Pakistan, half of the problems are linked to environment or climate in one way or the other. Utilities, water, clean water, drinking water. How do you really build the capacity of even the whole judiciary to take on climate and environment?
So that's a good question. You see, when the environmental law started in the constitutional court, this was primarily a constitutional court issue, because people were coming to the constitutional court directly to the High Court or the Supreme Court to enforce their fundamental rights. So the entire jurisprudence that is evolved has been on the constitutional plane. And there were some champion judges, but now I think that's a thing of the past. We have a lot more judges at the constitutional courts dealing with climate and environmental matters. But the question is very important. You see, in future, when we talk about climate finance disputes and loss and damage disputes which require evidence, they will not come to constitutional courts. They would go to the frontline courts. And we, having understood that issue, we have now started trainings at our Federal Judicial Academy, at our other provincial judicial academies on climate change. And we're now introducing, we just recently started a course from a professor at Oxford University to talk about climate science to our judges. Because sooner or later there's going to be issue that I have a loss and damage issue, sir, and the North or the global funds ought to give me X amount of dollars. Who's going to calculate that? Who's going to attribute it to climate science? The judge needs to have a good grip on it. And it's not going to come to the constitutional courts. It'll go to the frontline courts. So we are, in a way, if I were to say, that we're ahead of the curve. We've started that training program. By the time climate finance really matures and comes to the way that it has to, there will be disputes. I couldn't mention today, but there are climate courts that we want to talk about. We want to talk about climate ADR. We also want to talk about a global court like ICJ, because there's no way you're going to get funds from the North unless there's a policeman sitting somewhere. So things like this.
Thank you so much for joining us.
Thank you.
That was very informative, and I agree that it has to flow down from the top to the bottom, and now we're at a stage where Global South really needs to voice its concerns at the global level.
That's right.
So thank you for making that point. We will continue these conversations. Stay tuned.